Hello everyone, my name's Sam Baring from Hall & Wilcox Lawyers, and today as part of Law Week 2020 I'm going to talk to you about why you need a will. So in Victoria, where someone dies without a will, their assets are generally passed to a spouse or to a spouse and their children in accordance with the intestacy laws. Sometimes this won't create a problem for the deceased's family, but more often than not, complications will arise. The most effective way to avoid any potential issues is to record your wishes for the division of your estate. And the most effective way to do this is to ensure that you have a valid will in place. Not only does this provide you with peace of mind and security, but it means that the beneficiaries of your inheritance can benefit from the many structuring opportunities that are available to you. This session is going to take a look at what wills are, why you need a will, things you need to think about when you're putting a will in place, and the common things that can go wrong. So what is a will? Effectively, a will is a legal document which is designed to clearly set out your wishes for the distribution of your assets after your death. This includes all assets that are owned in your sole name, such as your house, bank accounts, car, and other personal belongings such as jewellery. However, it's important to note that there are certain assets which are jointly held, such as property, or there's superannuation or assets which are held in a separate trust structure that will not form part of your estate. In respect of jointly held land or bank accounts, these will automatically revert to the survivor. Superannuation is also dealt with separately via a separate nomination, and therefore, to flow through to your estate and to be dealt with by your will, you would need to make a death benefit nomination to your legal personal representative. Further, any assets which are held in a family trust will also need to be dealt with via a separate deed, passing control of the trust as these assets do not form part of your estate. From a high level perspective, your will should generally include who you would like to administer your estate, i.e. who your executor should be, who you would like to receive your assets, so the beneficiaries of your estate, instructions as to how and when the beneficiaries will receive those assets. Your will is also a vehicle for appointing guardians for your minor children, and any will should be witnessed by two witnesses, all of who use the same pen to execute the will. This way, the probate court know that you're all in the room at the same time. So we'll go through these later on in the presentation. So that takes us to why is it important to have a will? So having a clear, legally valid and up-to-date will is the best way to ensure that your assets are protected and distributed in accordance with your wishes. In effect, the best witness to what you want to happen to your estate is dead. And so the best way to kind of record this and how you want your assets to pass is by having a will in place. And where you don't have a will, you're no longer going to have control over the distribution of your estate, and the rules of intestacy will apply. And so the rules of intestacy are effectively a set formula which dictates which certain which relatives receive a defined percentage of your assets, despite what you may have wished. So this can obviously result in further unintended consequences, and we'll go through this a little later. But you're not going to have control over who is guardian of your children. Your children or grandchildren may not receive the financial protection that you desire. Partners, stepchildren, friends, favourite charities may miss out on receiving a benefit that you otherwise would have intended them to receive. Vulnerable members of your family, so whether from a personal or a family law perspective or even a creditor perspective, they may receive their inheritance in a manner that's not desirable. Your estate may be administered by someone that you would not have otherwise appointed. And your estate also might not be handled in the most kind of tax effective manner and not provide as many opportunities from a structuring perspective that you may have otherwise intended. So despite all these kind of potential consequences of not having a valid and legally binding will in place, studies show that on average 45% of Australians do not have a current will. And so obviously, as I just mentioned, if you do die without a will, nobody will know necessarily who you wanted to be the beneficiaries and who you wanted as your executor of your estate, amongst other things. So I might take you just to a bit of a case study to have a bit of a look through some of those unintended consequences that we spoke about. So in this particular case, we've got John and Sarah, and they've been married for 10 years. They've got 3 children, Sam, Mark, and Emma. And John and Sarah's relationship broke down a couple of years ago. Although they're separated, they haven't yet entered into a property settlement and are not legally divorced. So before the divorce is finalised, unfortunately, John dies. And so if we have a look at scenario 1, John had been working to put a will in place for a number of years. However, as often happens in life, work's busy, and the divorce proceedings or the separation was causing a bit of anxiety for him, and he kind of intended to get to it, but he never did. So when John dies without his will, unintended consequence, because he hasn't had a formal divorce and a property settlement, is that his house, his bank accounts and whatnot, automatically pass to his partner on his death. Now, this is a scenario which a lot of people aren't or don't find desirable, in the sense that even though his partner is the mother of his children, often clients will want that wealth, particularly where they're not currently with their partner anymore, to be held by their own family members for the benefit of their children. However, by virtue of not putting something in place, the intestacy laws in Victoria state that where you do have a partner and children from the same relationship, that 100% of that wealth will pass to the partner. So then if you have a look at scenario 2, so where John has separated, but he's also put a will in place, we've given him the opportunity there by putting his brother and his sister. He wanted them to receive part of the estate and also to hold the bulk of the estate for his children via a trust, which they are in control of, to make sure that that estate isn't whittled away and is spent on effectively his children. So by having a will in place, he was really able to put in place some clear direction as to how that money was to be spent, and to ensure that it was spent or preserved for his children, rather than passing to a partner who he may have an acrimonious relationship with at the moment. Another common kind of case study that we get is the blended family. And so under this scenario, you're looking at a situation where we've got John and Sarah, and they're both happily divorced. John's got his new partner who he's married a number of years ago. And he's still got his kind of children from the relationship, and his new partner, Kate, she's brought 2 children into the relationship as well. So they all live together in a property that's under John owns in his own name. And John wants to make sure that he provides for his biological children, his stepchildren, and his partner on his death. So it can be a little bit of a difficult type of balancing act to get all that in place. So again, if we have a look at scenario 1, we've got John been planning to put a will in place for years, but he's never got around to it. So he passes it away without a will, and then we need to turn to the laws of intestacy in Victoria. And so under this, Kate, his partner, receives all his personal chattels, the first close, around $450,000 of his estate, and the remainder of his estate is divided equally between his partner and his biological children. So, you may have a scenario where John's estate is valued at approximately 2.5 million, meaning his biological children are entitled to around about $1 million. If his wealth is kind of mainly tied up in say, the primary place of residence, the only way to get that $1 million to his children is to sell the house. And so where you've got a situation, if say the children and their step parent, in this case Kate, don't get along, and can force the sale of the house, and that can lead to all sorts of issues in terms of ensuring that Kate's still got it, properly provided for it, and got a roof over her head, and just by not having that legally valid will in place can cause a lot of kind of angst and unnecessary tension between the stepkids and their stepmother that we might have otherwise have been able to avoid with a will. So if you have a look at scenario 2, before he dies, John does contact us and puts a will in place. He's got clear instructions that he wants, his partner Kate and his stepchildren to have a right to occupy that home, or maybe he wants that home to pass to them, and then he looks to gift his brother and sister $100,000 each, as we touched on in the previous example, and then the remainder of his estate equally to his biological children, again via a trust scenario where he can have his family members in control of the benefit for his kids, just to ensure that it's preserved for their kind of education and long-term maintenance. So there's a number of succession planning kind of triggers that we suggest should prompt you to put a will in place, or at least have a look at updating your existing will. We're not going to go through all of these today, but we might just explain a couple of them further. So if you have children, you may want to ensure that they're adequately provided for in your will, and that you've appointed a guardian for them should you pass away prior to them attaining 18 years of age. You also see scenarios where wills have been put in place a number of years ago when there were just 2 kids in the family. 3 or 4, number 3 and 4 have come along subsequently. The will hasn't been updated kind of since then. And again, we can get some unintended consequences by having a will in place which actually isn't valid and it doesn't suit your particular circumstances at the time that you do pass. A relationship change. As seen in the previous scenarios, without a valid will, your estate may not be distributed to the people that you intend to benefit. So anytime that there's a relation change, there may be a de facto partner on the scene, a partner may have passed away themselves. It's always a time to update the wills and to have a look at, or to look at getting a will in place and have a look at that. A couple of points, so if I'll just go back, a couple of points that are also important to consider. That a marriage, it's not necessarily commonly known that a marriage will automatically revoke all previous wills. So if you have made a will before you get married and you still want to continue to provide for those beneficiaries or make arrangements to cater for the new circumstances, then you should be putting a new will in place, as whatever you had previously will be revoked, unless that will was made in contemplation of a marriage to someone. Also, a divorce, so a separation from a spouse, does not affect a will in the sense that the will not be revoked, although any gifts to your spouse or their appointment as an executor and whatnot are kind of automatically revoked, and the will's more or less read as if the partner had died. So those gifts, I suppose, or appointments skip the partner that's been divorced and move to the next as if that partner had not been surviving. Illness is another aspect or something that occurs where it might be prudent to get your will kind of reviewed. So if you get diagnosed with a terminal illness, such as cancer or contract a deadly virus, such as COVID in the current circumstances, you should certainly consider getting your affairs in order as soon as possible. And again, this will be touched on probably in other presentations, but also your superannuation, a terminal illness is a prerequisite for being able to potentially withdraw superannuation out of your fund early. And so you may want to get some advice in and around that. And finally, I suppose if there are assets which you inherit, say from a family member, or you purchase something of particular significance in terms of the totality of your estate, that also might be a reason to think about updating matters for future. So we touched on a little bit earlier, but some of the key things to think about when putting a will in place. So firstly, think about who should be your executor. So when you make a will, you need to nominate an executor, and that's the person that's responsible for ensuring the instructions in your will are carried out. In deciding on an executor, you need to know that there can be degrees of complexity in terms of appointing that role, and involves notifying government agencies of a person's death, locating beneficiaries and handling the probate process. So you want someone who's trustworthy, that knows your estate, and that's organised. It's common to appoint spouses or adult children as executors of your estate. However, if that's not appropriate in your particular situation, you might also consider appointing, say, a trusted friend, or appointing a professional executor, although they will charge their own fees for acting in that role. Also need to have a think about your beneficiaries. So they're the people who will be inheriting your assets according to the terms of your will. So this can be as simple as giving everything to your partner, and in the event that they don't survive you, then to your children equally. However, obviously family relationships can be very complicated, and so you may want to have a think about things like who would like to benefit. Can this be done by making a specific gift? Do you want to nominate particular beneficiaries to receive certain assets? Do you just want to treat everyone equally and more or less have it, everything, as I kind of mentioned, to your partner, and then equally between the children, and leave that up to them to work out who takes what, provided that it's all within their particular entitlement under the estate? It's also probably worth noting that if you are leaving, a child or someone with a lower proportion of your estate, or leaving them out altogether, then perhaps it might be prudent to put in place some reasons why you are doing that. We'll touch on kind of estate challenges a little bit later in the presentation, but any kind of documentation as to why you have left your estate the way that you have, particularly where it may be controversial, can't be a bad thing in terms of kind of safeguarding your executor and the beneficiaries down the track, should someone's notice be put out of joint by it. And finally, I suppose you should also have a bit of a think about, what might happen if, for example, you and your immediate family all die at the same time. So it's a bit of a morbid thing to think about sometimes, but yeah, often, particularly with young children or young families, we say, look, you should be having a think of what happens if you both and all the kids all happen to pass away in what would be a tragic accident. And so often, families might want 50% to pass to one spouse and 50% to the other spouse's family, but yeah, that default or that kind of worst case scenario should be considered. So when you're looking at putting a will in place, obviously we recommend that you do speak to a lawyer and get proper advice around that. And it would be good to go to them with what assets are in your estate, where do you want them to pass. We're often now dealing with how do you want your digital assets to pass. So things like PayPal accounts, Facebook accounts, who should be in control of those once you pass away. And finally, often people don't realise, but under your will, you do appoint guardians of your children. So it goes without saying that where one parent passes away, the surviving parent does get custody of any minor children. However, it is important to think if something was to happen to both parents, how you would like the children to be cared for, and who would be responsible for making those particular decisions. So what can go wrong? What are the consequences of not having a will or an inadequate will? And so kind of touched on a few of them, but obviously you can get these unintended results via the intestacy provisions. There can be delays and administrative issues in respect of kind of applying for grants of probate down the track. And I suppose by virtue of not having properly documented what your intentions were, it can lead to disputes arising on the back of that. And in this paragraph, we've just set out, a little bit about, the difference in terms of getting a grant of probate, which is an application to the court by an executor appointed under a will to go and administer the estate, as opposed to an application for letters of administration. And so a letters of administration is where there hasn't been a valid will left behind by the deceased, and they have effectively the person most entitled to the estate under the terms of intestacy are required to make an application for letters of administration. And so from a practical perspective, the two applications are similar. However, there are kind of further documentary evidence and administrative hurdles required to gain a letters of administration, which wouldn't otherwise have been required for a grant of probate. And this can obviously lead to increased costs for your estate and effectively, the people that you've left behind. It eats into their share of kind of what's available to them. But yeah, just setting out a few of the key differences in that slide. So here I've just set out, what happens if you don't have a will and those intestacy provisions. So if a person's property is not disposed of by a will when they die, that person has died intestate. And so this occurs where they don't have a valid will, and that is, or if their will only disposes of some and not all of their property. So if you die without a will, it's not valid. Again, as I've touched on before, you'll need a grant of letters of administration. So and we'll just go quickly through a high level of what happens under the intestacy laws in Victoria. So if you and a partner, if you have a partner and no children, then the partner takes the whole of your estate. If you pass away without a will and you have a partner and children of that relationship, then the partner will also benefit by receiving the whole of the estate. And we kind of touched on that in an example earlier in the presentation. Gets a little bit more complicated if you have one partner and then children born of a different relationship. Then the partner will receive all of the personal chattels and the first 450,000 and 50% of the balance, with the remaining 50% shared amongst the children. And so, as I touched on in that previous example, this can lead to some unintended consequences. If you don't have an estate that's of that scale, you may unintentionally leave very little or nothing to children of your first relationship, with everything passing to a new partner, which might not have been your intention otherwise. And then it continues to work down the line. But yes, it is a bit of a common misconception that if you die without a will, that everything just gets left to the Crown. But as you can see, it certainly works its way down through. Once you get past partners and children, then it'll look to pass to your parents, siblings, grandparents, and uncles and aunts. So it's very unlikely that it'll eventually be no beneficiaries there to receive anything and pass to the Crown. We'll just touch briefly on family provision claims, but any eligible person can apply to the court for a share or a larger share of a deceased person's estate within 6 months of the date of a grant of probate or letters of administration. And so at a really high level, who are the people that can make a claim on your estate and effectively, argue that the will did not adequately provide for them? That can be a spouse, it can be a child or stepchild or a person who believed that they were a child of yours, and so they're kind of the tier one people who are I suppose, able to make that claim. Tier two, other people who can also make a claim might be a grandchild or a spouse or domestic partner of a child of a deceased. But ultimately they need to be kind of a member of the deceased's household, a person who obviously had a very close relationship and were kind of had an expectation that they should be properly they should be provided for under your will. And so the court would take into account, the deceased testamentary intentions, the relationship between the deceased and the claimant, and any obligations or responsibilities of the deceased to the claimant. I won't run through them all, as it's not necessarily kind of specific to wills, but below you can see a number of the kind of the factors that the court can take into account in determining whether or not the will can be challenged and whether or not to uphold any challenge. So things like the nature and size of the estate, the age of the claimant, whether there's a disability, or the financial resources of the person making a claim. So you often see, the most common scenario is a spouse or an adult child, and they'd be making an argument that they don't have the financial resources to look after themselves, and therefore they had an expectation that their proper maintenance and support would be given by the person who has passed away. So in terms of the estate planning process, when you come to us or other legal advisors, is it's always important to meet with your lawyer to discuss what your wishes are and the options available to you, and really kind of set out kind of what you are looking to achieve with your estate plan. Go away, think about things, let your lawyers kind of draft up the documentation, and then come back for a second meeting where you sign up all your documentation, and go from there. So that's the end of our presentation. I hope that you've enjoyed it and you've gained a little bit of a better insight into wills in general, and the reason why it's really important that you do put a valid will in place. And I hope you enjoy the rest of Law Week 2020.